Good evening, everybody. My name is Ann Thompson. I'm the Assistant Director for Public Services here at the Essex Library, and I am delighted to welcome Attorney Erin Duques tonight to our Essex Library Zoom program room. So welcome, Erin.
Thank
tonight,
you.
Attorney Duques is going to provide us with estate planning 101 advice, and we are all very happy to be having that tonight from her. Just a few housekeeping notes as you come into the room, please. Please keep your microphones muted and your cameras off so we preserve the bandwidth. This meeting will be recorded and we'd love to save the bandwidth on that. The recording will be posted on a YouTube channel in the next couple of days so that if you miss something, you can listen to it again and it will be there for a bit. The state library requires me to report attendance statistics on an annual basis. So you'd be doing me a huge favor. I'm going to launch a poll right now. If you would let me know if there's anybody sharing your screen with you tonight, go ahead and just click on those answers where appropriate. And that is very, very helpful for me. So I don't have to guess and see how many people may have attended. And we'll let that go as people come into the room. Go ahead and fill that out. And in the meantime, I will let you know Attorney Erin Duques is an estate planning attorney with the law firm Czeipiga Daly Pope Perri and is based in the firm's Madison office. Erin is a member of the Connecticut Bar Association Elder Law, Trust, and Probate sections. She lives in Madison and with her family and serves the Madison community on the town's Board of Selectmen. So she's got a lot of plates in the air and we are very grateful for her time tonight. So I am going to end that poll in 3, 2, 1, and we'll get out of there. And with that, I give you Attorney Duques.
Okay, thank you very much, Anne, for the introduction and welcome everyone to the presentation tonight. On Estate Planning 101. We'll cover the basics of estate planning. I've tried to include things that I think would be of interest to you, but I do welcome you to enter questions into the chat box and they will be monitored. I'll be taking breaks to answer questions. So if there's something that I have not covered or if you're looking for additional information on it, feel free to type that into the chat. So as Anne said, my practice is exclusively in the areas of estate planning, as well as elder law and disability planning. So I also do planning for families who have family members with disabilities. And I'm happy to be here tonight to share some important information. So what I want to focus on tonight is really kind of 4 key components of estate planning. 2 are kind of focused on planning that should be done, well, this all should be done during your lifetime, but on what can happen during lifetime. And then the other components have to do with what happens after you die. So we often just think of wills when we think of estate planning, but there are some other important pieces that you should consider. And the first of those is a power of attorney. So a power of attorney is a legal document wherein you authorize someone, an individual who's called an agent or sometimes an attorney in fact, to handle your financial matters during your lifetime. So oftentimes people can get confused between an executor and a power of attorney. The power of attorney expires when you die. So if you've named someone to be your power of attorney after your death, that they cannot still access those assets. The power has expired. So that's an important something to remember. So what does the person do who's been authorized to do for this duty? And so what they typically do is basically they have the power to do whatever you do in your everyday life. So paying bills, going to the bank, managing or accessing investment accounts, online accounts. If you have a question about your Comcast bill, that person could call up Comcast and speak on your behalf. And believe it or not, if your spouse's name is not on your Comcast account, then many of you may have actually run into this where Comcast will not talk to the person. unless they have power of attorney. So it's pretty broad. And I often hear from clients, well, I don't need this right now because I'm healthy. I don't need someone to act on my behalf. Well, just because you've named someone, that doesn't mean they have an affirmative obligation to do anything for you. That just means they have the authority to do so. So for many people, they will just put these documents in place and then just have them for a later time. The other thing to remember is that if you're incapacitated, then it will be too late to execute a power of attorney. So if I have a client who is married and comes to me and says, my wife is in the hospital, she has dementia, I'd like to do a power of attorney. Well, at that point, it's too late because that person doesn't have capacity to sign this legal document. And so then we have to kind of resort to other things, which can include having to have the person conserved, which requires going to the probate court and producing evidence that the person can't manage their affairs and having someone named so that they can do so. So it's important to have in place because we just don't know what's going to happen. The other thing is that I feel that a lot of people think that because they're married, that their spouse would have this power. And in fact, that's not the case. So if you have an asset that you own jointly with a spouse, then certainly either spouse can access that asset. But if you have assets or accounts that only have your name, then someone would need to have legal authority to access or get information about those accounts. So that's important to remember. The other thing is I just wanted to kind of point out that there are two types of powers of attorney. So for people who are nervous about giving someone else these authorities during their lifetime when they're healthy and able to make their own decisions, we can do what's called a springing power of attorney, and that takes effect only upon the person becoming incapacitated. So it's called a springing power. Otherwise, the powers become effective immediately upon signing. But again, that doesn't mean that someone has to actually do anything with them. It just gives them the power to do so. So the powers of attorney, after there was a legislation passed in 2016, powers of attorney are durable, meaning that they stay in effect even if you become incapacitated. They also provide for powers over additional things like digital assets. So social media accounts and emails, you can give authority for your power of attorney to access those types of things. And the power of attorney also can be, it's a standard form, which anybody can get on the state website. There's a short form and there's also a long form. And it can be written narrowly or it can be broad. So with the passage of legislation in 2016, you have the ability to authorize certain what we call hot powers. So those are things like allowing someone to change beneficiary designations or allowing someone to create a revocable trust on your behalf. And a lot of these powers we see or we need when someone's incapacitated and perhaps we're trying to get them eligible for public benefits and they're not able to transfer assets or change beneficiary designations. So typically we recommend that if you have someone who you trust who's acting as your agent, that you do give them these powers. So from a practical perspective, a couple of things just to be aware of. I recommend to clients that they name a backup to the person who they're naming. So if they've got, if someone's married, they typically name spouse, but it's good to think about naming a backup. So if spouse couldn't act, who would that person be, who you'd want to have that authority. It's also important to review the power of attorney document as time goes on, to make sure that it includes the powers that you might need. So for example, a power of attorney for someone who's in their 30s, the thought of needing something for Medicaid is probably not high up on their list. But as people get older, if someone comes into my office with an old power of attorney, I will check it out and make sure it has some essential powers that I find that we can sometimes need in when we're representing clients. The other thing too is that you may consider giving it to a financial institution prior to an emergency. So if you're helping out a parent, for example, and you want to get on the account as power of attorney, you don't have to wait until there's an emergency and the person can't access it and you have to step in. Because oftentimes what happens is a financial institution is going to review the document and they're going to make sure that it looks okay before they're going to actually allow the agent to act. So it's really a better idea to submit that in advance. So there's some limitations with the power of attorney. So certainly the powers can be broad to control various aspects, or control meaning really access, manage aspects of your financial life, including paying bills, banking, investments. If there's an issue with Social Security, the person could call Social Security office on your behalf. But the limitations are that the agent can only do what the document allows them to do, which is why it's important that it has all the necessary powers. And that when the principal dies, the principal is the person who creates the power of attorney, the agent can no longer act. So those are the limitations. And so what type of, who should serve? So I get this question sometimes from clients. And so obviously a spouse, or sometimes a parent or family member or a friend, as long as it's someone who you trust, who you think is going to act on your behalf, who's going to take the responsibility seriously. And then another important aspect is someone who is organized, because they are required to keep a record of all the receipts and disbursements and transactions that they're making on behalf of the principal. So you want someone who's going to have, good record keeping. The person doesn't have to be an expert in financial affairs, because they can certainly consult with other experts, just as you or I would. So that's not necessary. Someone asked me, can a power of attorney handle real estate matters? Yes, the real estate is a common power that you would see in a power of attorney document. So selling real estate, leasing real estate, buying, all those types of things that have to do with real estate are typically included. So the other
Hey, just real quick, Erin, could I
Yeah.
jump in and add a little something too here? I'm
Sure.
Kevin. I work with Erin at the law firm. I handle marketing for the firm. And one of the things I just kind of wanted to emphasize, and Erin, feel free to chime in here, was the whole thing when she mentioned in 2016 there was a change to the power of attorney laws. So I'm assuming a lot of you that are listening with us and participating tonight already have a power of attorney. If you had that power of attorney and it was created before 2016, you might want to have, your attorney or whoever drafted for you, maybe take another look at it just to make sure that you have these new powers, active on there, and that it's durable too. That's the important thing. I mean, the power of attorney you still have, and Erin, please chime in, it's still active. It's not like it's no longer good, but you might want to just make sure and have that document reviewed to make sure it has all the necessary things that came out of the changes from 2016. Is that a good thing to say, Erin?
Yep,
Okay.
absolutely. Just as you should review them periodically, that's a good reason why it should be reviewed, because not only do life circumstances change, but there's changes in the law, which is why it's important to review all your estate planning documents. But specifically, yes, there were important changes in 2016.
And it looks like we had a couple of other questions come in here too.
Oh, can we
see those, Erin? Someone says, could we have access to the slides? Yes, I could give a copy to Anne at the library, and she could definitely share them with anyone who asks. And then Anne's chiming in saying that she has a handout for anyone who's going to request it as well too. So there we go. So with that said, Erin, I'll I'll go away and let you continue on.
Sure.
Right.
And then Lisa just asked a question. She beat me to it because that was going to be my next point. She asked, can your lawyer act as a power of attorney? And the answer is yes. So you can have a professional, some accountants will do it, an attorney, a financial institution. Those can be good options if you don't have someone who you're close to, who you trust to do it. Or sometimes people are just concerned about picking perhaps one child over another, or other reasons they want an independent party to serve. And that also applies to executors as well. A professional or independent person can fit some situations quite nicely. So we're going to kind of switch gears, but a similar theme, which is living wills and healthcare representatives. So the healthcare representative or the healthcare document is important. What it does is you appoint a healthcare representative to make medical and healthcare decisions in the event that you are unable to make them for yourself. So this is different from the power of attorney, which if you have a general power of attorney that takes effect upon signing, that the authority is effective upon signing, excuse me. The healthcare directive is effective only if you can't make a healthcare decision. And that's a good thing because, you know, many of us don't want someone else making our healthcare decisions for us. So what happens if you're incapacitated and don't have a healthcare directive in place? So many people, again, like the power of attorney, just assume that spouse can make these important decisions. And I just wanted to point out that there is the legal side of things and there's the practical. From a legal perspective, just because you're married does not mean that your spouse has the legal authority to make healthcare decisions for you. Now, I understand in real life that healthcare professionals will allow a spouse to, even if in emergency situations, but legally speaking, there is no legal authority unless you've given that to the person through a healthcare document, or if you're conserved, again, and the court has appointed someone to make healthcare decisions for you. Similar to the power of attorney, there was a law change in 2006 that allowed the healthcare representative to make medical and treatment decisions in addition to decisions regarding life support. So if you've got an old healthcare document, it may not include those powers. So that's something that you want to check on. You could also, with the passage of the law in 2006, you can make the choice if you want to be kept alive to bring a fetus to viability if you are pregnant, and it includes end-of-life decision-making. So this is an important document because you're going to give someone the authority to make healthcare decisions, and you're going to want to choose someone who you trust is going to make the decisions that you want them to make. So the question becomes, well, how do they know? So I have clients who say, well, how will they know what I would want? So there's a couple of different things to talk about in that regard. First is a living will. So the living will we include it within our healthcare document, but it's a document where you can identify the medical interventions and life support you want if it's been determined that you're in a permanent vegetative state or coma and there's no possible chance of recovery. So in that event, you can indicate what life support you would want at that time. What this does is it takes that decision off of the healthcare representative. So if we're in a situation where a son or daughter is serving and they are faced with this question, if you've done a living will, then the answer is right there for them. But the other thing is that an important part of this is the communication with your healthcare representative to let them know what your desires are. And there are documents available, and I don't know if there's an example here. It's called Your Way. This is something that you can get from the internet. There are nonprofit organizations out there that have these, and it's just a template which you can fill out to give more specific instructions about what you would want if you're incapacitated. So that can be an important guide for whomever you're choosing to serve as your healthcare representative. The other practical piece of this is it's important to give the healthcare document to your physician so that they can have it on file. So if there's an emergency, there's not, scrambling to find out if the person actually had a healthcare representative and who that person might be. So this is just kind of a recap. The person is called the healthcare representative, and the power to act also expires upon your death, just like the power of attorney. So the power is to make any and all healthcare decisions. If you are unable to do it yourself, the person can accept or refuse treatment on your behalf. They can only act if you're unable to make a decision. And the decisions are based on your wishes to the extent they are known, which is again why it's important to communicate what your wishes are. And the expectation also is that the healthcare representative is going to act consistent with decisions that you have made for your own healthcare in the past. So keeping this in mind is, when you're deciding who to choose to do this role, these are the things to be thinking about. Okay. Just checking to see if, before we switch over to wills and trusts, just checking to see if there's any other questions on those two. And it doesn't look like there are. So, so now getting on to the topic of planning for after death. And one of the important documents is the last will and testament. So why is it important to have a will? Without the will, it's the state of Connecticut would be, and the statutes would be determining who gets your property at the time of your death. And this may or may not be consistent with your wishes. So as I'm going to give you a few examples of that based on our laws of intestacy. So if you're married and you have two children and you pass away, many people might think that your spouse gets all of your assets because many of us leave all of our assets to our spouse when we die in our wills. But the spouse gets the first 100,000 of the estate plus 1/2 of what's left, or 1/2, and then the children, I'm sorry, whatever is left, they get 1/2, and then the children get 1/2. So that might not be what you're wanting for your estate plan. If you're married and you die without children, but your parents are still living, the spouse gets the first 100,000 plus 3/4 of the balance, and then the parents actually get the remaining assets in the estate. If you're married and have children with someone other than spouse gets 1/2, and then the descendants inherit everything else. So this is just to kind of give you an example of that what you think may happen may actually not be truly what happens under our statutes as written. So the will is important.
Just really quick, I'm going to interrupt really quick, Erin. So Anne mentioned that handout that she has available for anyone who has, but that anyone who wants it, she's going to send it to you. In that handout, we have all of these rules from the state that Erin just talked about. There's like a table inside of that handout that shows all these things and what would happen if you passed away without a will. So if you're trying to write that down fast, don't worry about it. I request a handout, and all the state rules are in the handout that you could get from Anne. So just wanted to mention that. So thanks.
Great. So a will also allows you to make specific bequests. So if you have items of personal property that you want to make sure go to certain people, then you can indicate that in your will. You control who manages the estate after you die by naming an executor. For people who have minor children, the will is where you would name a legal guardian for your children. And the will also helps you to determine or allows you to determine how assets are left to your beneficiaries. So for some people who have minor children, or who may have a child with a disability who is on public benefits or maybe on public benefits in the future, they may consider leaving assets in trust for that beneficiary. And sometimes, particularly in the case of minor children, the trust may end at a certain age, like 25 is typically the default, but you can indicate, you control what age within the will that the beneficiary would have access to those assets. So I want to just point out what assets pass under the will versus what assets do not. So the will is what's going to dictate what happens with the assets in your estate, so your probate estate. So any asset that you own jointly with someone else, upon your death, it becomes the surviving owner becomes the sole owner just by operation of law. So we don't need probate in order to transfer legal title from the decedent to the new owner because of that joint ownership. Likewise, for assets that have beneficiary designations, so typically retirement accounts, those also pass outside of probate as long as you've named a beneficiary on those accounts. So a lot of times people are surprised to hear that the beneficiary designations in essence trump the terms of the will, but that's true because those assets will pass outside of probate. So the provisions under the will do not control the distribution of those assets. So that's an important distinction. So the executor is the person who manages and oversees the estate. You don't always need an executor. So if in Connecticut, we have a process for a small estate that has assets under $40,000, as long as there's no real property, then an executor is not needed. The person is called a personal representative, and it's a much more informal and typically faster process than a full probate. So the executor, just to kind of touch upon what that person does, sorry. So it can be a big job, depending on the nature of the assets in the estate, but they're going to be responsible for figuring out what assets the person had at the time of their death. They're going to need to know what the value was as of the date of the date of death. They're going to need to be accountable to creditors. So if a creditor makes a claim against the estate, they're going to have to either deny the claim or pay the claim. They're going to need to provide an inventory to the court, which shows all of the assets the person owned at the time of their death. And then they're going to need to open an estate account and create a final accounting at the end showing what the value of the assets were at the time of death, what had been paid out of the estate, any income that had come into the estate, and then how the estate should be distributed based on the terms of the will. So there are some responsibilities definitely associated with executors. So something to be thinking about when you're trying to decide who the executor should be under your will. Okay. So just to review, so the executor will secure the assets after death, deal with creditors, make sure the beneficiaries get what they are entitled to under the will, and have to comply with all the requirements as far as the filings with the probate court. No control over assets that are jointly owned or ones that have beneficiary designations. And the executor has the authority that's outlined in the will. So if there's a power that they don't have, they will have to get it. They will have to ask permission from the probate court. Again, a lot of times we name We see people naming their spouses. As children get older, they might want to name their children as executor. And then there are also professionals who can serve in this role, attorneys, accountants, sometimes financial advisors will serve as an executor. An executor has a fiduciary responsibility to the beneficiaries, so they have to carry out their duties in that capacity with regard to the beneficiaries. Oh, okay, I had a couple of questions. What's the typical percentage an executor gets for managing the process? So, so many times the wills will say that an executor can be reimbursed and can be compensated. And so it really depends on the amount is basically what the law says, that it has to be a reasonable amount, which is not very instructive. But it has to be consistent with what the person is doing. So if it's an attorney who is serving as an executor, then they would be entitled to typically to their whatever rate that they bill at, as long as it's, again, as long as it's reasonable. So whatever you end up paying the executor ends up getting paid out of the estate, they are going to, it has to get approved by the court, that amount. So if it's somebody who it's a family member, then it can be an hourly rate based on their time. And they would have to keep a record of what time they're putting in to the estate. Can a lawyer act as an executive? And the answer is yes. Okay, so the other component of the estate planning is, which I kind of went over already, is the importance of making sure that your beneficiary designations on your life insurance, your retirement accounts, they are aligned with your overall plan. So if you have a very well-designed will or trust, but you haven't put your beneficiary designations so they're consistent, because that's going to go to those beneficiaries outside of the will, you might not be actually, your plan may not unfold the way that you wanted to. So it's important that those beneficiary designations line up. Also, for a specific example of this, if I have trusts for my children under my will, so that if they're under a certain age, their inheritance goes into a trust for them, I will want to make sure that my beneficiary designations also say that. So if I have a large retirement account and I haven't named the trust as a contingent if the person's under 25, then it's going to go outright to them, which wasn't my intent. When I created my will, I specifically created trust for them. So those are some of the things that we look at when we're with clients. We don't just draft these documents that stand alone. We want to look and make sure that all the pieces fit together. You want to make sure that you have beneficiary designations on your retirement accounts. This is really important because there are tax implications, income tax implications if a retirement account pays out to an estate. And what I see in my practice is that many times people will have, if they're married, will have spouse as primary, or will have someone named as primary, but maybe do not have a contingent. And that's really important, because if you don't remember to go back and add, if your primary isn't living anymore and you don't go back and change it, now you don't have any beneficiaries named. So that's something I often recommend to people, that they go check on that and make sure that they've got contingent beneficiaries named. One thing I also want to point out is that I see with my clients that as they get older, they will add a son or daughter to an account. And the thinking being that that child is going to be helping them pay bills, helping them. There's a couple of risks with this kind of setup. One is that child is then legally the joint owner of that account. So as I mentioned before, if you pass away, then that child is going to then become the owner of that asset. So if it's your intent that when you die, your children are going to inherit everything equally, that outcome is going to be different because now that child has inherited that specific account. Now, if it's a small account, a working account, like a checking account, it might not be an issue, but it's just something to be aware of. The other thing I would like to point out to people is that as the legal joint owner of that account, those assets are subject to whatever is happening in the life of that joint owner. So if they're sued or if they get a divorce, it puts that account at risk, which is really your account. So I tend to recommend that people, especially if it's a larger asset, that they will get on that account as power of attorney. So that will allow them to have access to the account and to be able to help out mom or dad, but we don't have that issue of ownership of the asset. So just a couple of points of practical advice that you should revisit your beneficiary designations frequently and see if they need updating, because as life changes and kids grow up and assets change, then it may be important to make minor adjustments to those. And the other piece of advice is, again, just to make sure that you check and make sure you've named contingent beneficiaries on those accounts. Okay. Well, so this is just to kind of point out the one thing that sometimes people lose sight of, which is that estate planning is not just about documents. It's about the people who you name to carry out the various duties, both while you're living and then after your death. And so it's really important to put some time and some thought into who you're naming, what their skill sets are, because someone who would do very well as a power of attorney may not make the type of healthcare decisions that you would want them to. So I know that this is something that I see a lot of parents struggling with. They feel that they have to put all their kids on both of these documents, but I encourage clients to really think about who is best going to serve this role for you. So that's something to really give some thought to. So I wanted this, this is a basic estate planning presentation, but I also wanted to just point out from a high level, wills versus trusts, because I get a lot of questions about that. What is a trust and should I have one? So a trust is another mechanism where you can control where your assets go at death. The difference between a trust and a will is that a trust gets created and funded. And why I say funded, I mean assets get placed into it during lifetime. There are different reasons for having a trust, which I'll go into. When we're talking about basic estate planning, we're talking about revocable trusts. You may have heard about irrevocable trusts, which have to do with there's different reasons for doing that, perhaps taking assets out of your taxable estate, or you may have heard of life insurance trusts or asset protection trusts. Those are all a different kind of class, a category of trusts, which I'm not going to really go into too much this evening. But when we're talking about basic estate planning, we're talking about revocable trusts. So you're going to have the grantor is the person who makes the trust. The trustee is the person who manages and controls the assets within the trust. And the beneficiaries are the ones that are ultimately going to benefit from what's in the trust. But the trust distribution provisions are very similar to those you would have in a will. So it says, when I die, this is what's going to happen to the assets. So why have a trust then? So there's a couple of different reasons commonly why people might choose to have a trust instead of a will. So again, ultimately they do the same thing, but you would have one or the other. So one of the reasons is for probate avoidance, because as I mentioned before, if someone is the owner of an asset and they die, unless there's a joint owner named or a beneficiary, the only way to transfer legal title is to go through the probate court process. So if we create a revocable trust and we put assets into it, so we can put the house into it. We can put accounts into it. And we've named beneficiaries on our retirement accounts. There's no need for probate to actually transfer ownership of that asset, because at the time of death, the living trust becomes irrevocable. It becomes an entity with its own tax ID number, and then that entity, which is governed by the trustee, distributes out the assets within the trust to the people who have been named as beneficiaries. So probate avoidance is one reason sometimes people, particularly if they have assets in another state, if they have real estate in another state and they don't want to have two probate estates, that could be a reason why. The other reason why sometimes people do a living trust is because there's privacy. So if you die and you have an estate, that those documents are public, and there might be situations in someone's family where they don't want family members to be able to access what is in those documents. With the living trust, there are ways to set it up so that a beneficiary cannot get access to the trust, can't see perhaps what someone else what a sibling is getting compared to them. So that might be, that privacy is something that can be important to some people. And the other kind of common one is sometimes if, as I mentioned earlier, if you have a child with a disability, or if you have other reasons why you don't want to leave things outright to your children and you want to leave it to them in a trust, you can, it's more efficient to create a trust under the living trust, because if you create it under your will, then there'll be probate court supervision over that trust for as long as it's in existence. So there are some benefits to doing it underneath a revocable trust. But these are all the conversations that you should be having with your estate planning attorney. So it's not really about just drafting the document, it's trying to figure out what is going to be best for your particular situation. Oh, and this kind of leads me into here. Again, so you want to make sure that you're going to have someone who's addressing all of your needs and concerns and the specific circumstances of your family and your life. So someone asked, can a beneficiary manage a trust? So yes. So a lot of times people will, if they set up a trust and they'll have spouse on as a co-trustee, and as they age, they'll also have successor trustees, and successor trustees are often the children who are also ultimately the beneficiaries of the trust assets when they pass. So that is pretty common. Anne asked, are there limits to living trusts, high or minimums? So there's no specific limits, but from a practical perspective, you're going to want to think about, especially if you're thinking about leaving assets in trust for a beneficiary. So a trust is obviously, there is some requirements or some things you have to do to manage the trust. You have to, for an irrevocable trust, so a trust you create for someone else, you're going to have to file a tax return. You're going to have to answer to the beneficiary. You're going to have to make sure that you're staying on top of what's happening with the assets within that trust. So there is work to be done there. So to answer that question, I think when someone's considering whether or not to create a trust for a child, they need to think about, well, how much actually is going to go into that trust? And is it worth that for that amount? So that's some guidance as far as whether or not a trust would be appropriate for a specific situation. There are some circumstances, like for example, if someone has a child with a substance abuse issue, where they're just, to leave money outright would be a terrible decision, and the amount isn't quite as important because the person just says, I don't want this person to get this money when I die. And so we can always create a trust for that. So someone asked, can a power of attorney, so can an agent under power of attorney make changes in a revocable trust? So that would be an example of one of those hot powers that I mentioned to you. So one of the hot powers that you have to actually initial in the power of attorney document is to allow your agent to create or amend a revocable trust. In the absence of that language, then the power of attorney cannot do that. Someone made a comment saying that there's no way to avoid probate after talking to a probate judge. So that is, I think what that's referring to is that if you, because you don't need probate to transfer title under a trust, but if you have property, so if you own real property, even if it's in trust, you will have to file it's called a Connecticut 706 NT form if you have no estate tax owed. It's an estate tax form that has to get filed with the court. And the reason it has to get filed with the court is because when you die owning real property, the state of Connecticut will put an automatic lien on that property until it knows that you don't owe any estate tax. So once you file that document and they determine no estate tax is owed, the probate court will issue a certificate of a release of lien, which then would allow the beneficiary to transfer that property, because you can't transfer property if it's encumbered by a lien. So in those cases, you would need to file that document with the probate court. But I don't think, generally speaking, that statement is true, because you can avoid probate by having a trust. You can avoid probate by having a beneficiary designation. What you're avoiding is the full probate process. The process which I explained, which is filing the inventory and paying creditors. That's what you're avoiding. You're avoiding that 9 to 12 plus month process where someone can contest what's in the will, and all types of things can happen.
Erin, how about the fee? Maybe that's something they were talking about too, because you can't avoid the probate fee, correct? That might be what the person's referring to.
Well, you can avoid the probate fee if you don't have to file that 706 NT. So if you don't have property, but once you file the 706 NT, the estate tax form, the probate court assesses a fee that is based upon the value of the gross taxable estate. So it's not the estate tax that's owed, but it's the probate court fee. And really it's those fees is what keeps the probate courts running in the state of Connecticut. Typical costs of trusts once the principal dies. Okay. So I think that means administering a trust. And so that would, I guess it would depend on what you're for an attorney, if you're hiring an attorney to assist with the trust, or if you have an attorney who might be serving as the fiduciary, as the trustee, they would have fees. So it's that's sort of a difficult question to answer. It also depends on what assets are in the trust. So if there's real estate, and that has to be sold. So it's kind of difficult to give a specific answer to that question. Is there a probate fee for just a will? I'm not 100% certain of what that is asking either. Again, the probate fee is calculated based on what's in your gross taxable estate. And that, don't be fooled by that, because gross taxable estate, that just means the amount that you own at the time of your death. It also includes retirement accounts and life insurance. And so that's what once you open an estate, so once you file the will and you open an estate, then that 706 will need to get filed. And that's what the fee is based on.
And the fee is generally pretty small too, isn't it, Erin? I mean, I think it's a scale, right? But generally, isn't it only like 1/2 of 1% or something like that?
Mm-hmm.
Yeah,
it is, and it does go up based on the total of the number of assets. So if you do a living trust instead of the will, you will not file. So you will, it's really dependent upon, if you don't need the court to transfer assets and you don't have real estate, then you may not need to go to the probate court at all. And you're welcome. Any other questions? We can kind of wrap up here. My email address is on the screen here. So if you do have a question, you can either submit it to Anne and she'll pass it along, or you can email me at my email address here.
Hi, Erin, this is Anne.
Hi.
Just a quick question that was mentioned at pre-talk about an attendee tonight who asked about being disabled, and if there certainly are special circumstances in that instance, and if you could maybe just touch on some of the issues and
Sure.
the concerns they may have dealing with the disabilities and their securing their future.
Okay. So number one is it's going to be essential that there are powers of attorney and healthcare documents in place for both spouses. Questions specific to disability are really dependent on what types of benefits that person might be receiving. So public benefits have different requirements with regard to asset limits and income limits. So they would really kind of guide some of the planning that has to get done. So for example, if you have a married couple and one spouse is on benefits, could be on Medicaid, then there will be asset limits that will apply to the couple as a whole. So there's some strategies that we can implement to try to preserve additional assets above what the state has said is the limit. We also have to tailor the estate planning documents accordingly. So if you have a husband and wife and one is on Medicaid, then typically, and perhaps in a nursing home, we may want to bypass the spouse at time of death, because if they're on benefits, the healthy spouse doesn't want to leave everything to spouse anymore, because then that will make them ineligible for those benefits. So there's really a lot of different things to think about and address. And in that case, I would really suggest going to an attorney who really is well-versed in those areas. There are attorneys who can assist with applying for Social Security disability, if that is something that you could qualify for. So it's also helpful to talk to someone who might be able to give you some instruction and guidance on what you may qualify for, which again is dependent on age and disability, and it's really quite a extensive world when it comes to that.
Well, as you all are taking all that in, I'm just showing you the handouts that Kevin Rydell has very kindly put together for us. We have physical copies, print copies that are available, a number of them at the library. But if you would like to have one emailed to you, I'm just going to post a poll here that would allow you to let me know. Let's see if I can get to it just right. Sorry. Close that poll first. If you want to put it in the chat, if you would like to have one. Otherwise, I will just blanket mail a copy of these to everybody who registered tonight, and we'll leave it at that. It maybe is easier. With that said, Erin, I can't thank you enough, and Kevin, both of you, for all the work you've done to bring an incredible amount of complex and very high level information to us in a way that we can understand. And I know there's so much more that is available and necessary for folks to know about estate planning. So many, many thanks to you both for this. And I thank everybody for coming out and joining us tonight. And please don't hesitate to let me know if you have extra questions, or to go ahead and email Attorney Duques with questions directly. And if you enjoyed this talk and want more information, go ahead and let me know, because we'll try to get Attorney Duques and Mr. Rydell to come back and provide us more. And maybe I know there's lots and lots of legal topics that would be very helpful for the community. So thank you.
Right. Thank you very much, everyone. And I also just want to reiterate, if there are specific topics that you'd like to hear more about, the more specific the topic, the more we can really delve in. So we kind of tried to cover a lot here, but I'm more than happy to come back and speak on other topics as well.
Great. Thank you so much.
Thank you.
Any last questions? It's going once, going twice. All right. Thank you, everybody.
Good night, everyone.
Have a great Wednesday night. Take care.